And welcome to another episode of PLA with myself, Nick, and Bruno. We've got two questions today, and we'll take the first one with Nick and then the second one with Bruno. Nick, the first question goes as follows. We have an occupier who never paid a deposit or any rent. He found the keys to the property that he was viewing. The lease agreement was then signed, but no monies were paid. The lease states that only if a deposit is paid, the lease becomes valid. Now, do we need to commence an eviction process to get him out of the property, or is this a case of trespassing?
Perfect. So it's an interesting question. I've got some concerns about how the tenant found keys to the property in the circumstances when a lease agreement was signed. But putting that aside for the minute, with regards to this question, so we need to be careful. There's obviously in law, we do have laws relating to trespassing. It is a criminal offense, and you can have police remove people who are trespassing. But what we normally do when it comes to trespassing cases is it's really a question of time. Okay. If someone is trespassing on a particular premises, what's fundamental from my client's perspective when they come to me is you need to firstly know how long has the person been on this particular premises. Okay. If a person is using a property as a residence, temporary or permanently, this is what the legislation says, you are going to have to seek an eviction application. Okay, you cannot just approach the police and say to someone that they're trespassing if they've been staying there for a long period of time. So really, it's a difficult thing to do, but trespassing is something that you need to move on as quickly as is possible. We don't have in this question how long the person has been in occupation of the premises, but I would say there are indications that this isn't really a case of someone having trespassed on the premises. There seems to be some sort of indication that they were going to rent the property and they haven't fulfilled the obligations of the lease agreement that was signed. Now, the point that they make, there is a clause in terms of the lease agreement that does say the lease is not going to come into place until it is signed by the tenants in the circumstances. And that's a solid clause that you can include in terms of the lease agreement. Notwithstanding, remember, we don't just bring eviction applications in terms of people that have lease agreements in respect of premises. Okay. If you want to eject an unlawful occupier that never had a lease agreement, you still have to approach the court to do a proper eviction in the circumstances. And where you've cancelled the lease agreement for whatever reason, or terminated the lease agreement for whatever reason, you still have to approach a court to do an ejectment. So I understand the sentiment that the person has said, well, if the lease didn't come into place, that simply makes the person who's in occupation of the premises an unlawful occupier like every other circumstance. And in those circumstances, you're going to have to bring an eviction application. It's never as simple as you can simply go to the police and tell them, well, this person's unlawful, occupying unlawfully. You're going to have to do an eviction in the circumstances, and we get this from our legislation. Our legislation protects, the rights of even temporary occupiers of a particular premises. You cannot simply have them chucked out on the basis that it's trespassing in the circumstances. So, unfortunately, my answer is you do have to go through the eviction process at this stage.
Tell me, Nick, in your opinion, when does, I know there's no it's like proper answer for this, but maybe just for the sake of it, when does the trespassing turn into intention to permanently reside?
Or it's a good question. I know why you ask, because it's one of those things that how long is a piece of string? Yeah. It's one of those things that how long is a piece of string? Look, it's got to be assessed on the circumstances of the case. So the reason I give my answer the way I did, and I'm not sure, maybe you disagree with me, Bruno, is the fact that there was some sort of negotiation beforehand, some signature of a document, and then a non-performance in terms of that document does not allude to me that there's been some form of trespassing. And as I pointed out at the start of this question, I have a little question mark around how the keys got into the hands of this particular person. It might be the case that they found keys. Hell, maybe they snagged them off the table and didn't tell the agent at the time. But I think there's a chance that they were handed over to the tenant, or to the occupant rather, at some point, which doesn't lead me to believe that there's some unlawful trespassing. If the circumstances of the case were different, let's say that this person was in the property and they had gained access of the property, there was no lease negotiation, no showing the person occupant the property, and they had broken in through the front door, and the front door was now sitting ajar on the side. I think the facts of your case might be a bit different. Okay, provided you hadn't let them stay there now and given them some, not actually acted on it, then you've got a very good case to say to the police, listen, someone is trespassing, they have broken into the house, and there's a myriad of other things that might be criminal offenses. In those circumstances, absolutely, but I have a difficulty with this case because for all intents and purposes, the actions up to the point of the tenant getting occupation of the premises seem to suggest to me that they intended to enter into a lease agreement. And the tenant is not performing in terms of the lease agreement, and there is a good argument, as the writer points out, that the lease actually never came into place at all. Absolutely perfect. Does that make it trespassing? I don't think so in this particular case.
Sure. Yeah. Okay. So thank you very much, gentlemen, for that one. And then the second question, Bruno, and we are continuing with the mandates discussion as we go along on the episodes. So you might have to expand a bit on this question just to provide a better feedback and for our viewers there. But this one is just one sentence, and it says that please briefly discuss why one is not allowed to have a sole mandate clause in a lease agreement and the consequences if one does have such a clause.
Cool. So practically speaking, again, when we start having conversations around mandates, so remember, mandate is an instruction, an engagement, you can call it an agreement, a service level agreement, whatever you want, between the landlord typically in these instances and the estate agent, whether it's a procurement mandate where the estate agent's only responsible for finding a tenant, versus, for example, a management or a management mandate where the estate agent or the leasing agent is responsible for ensuring that whatever the premises are kept up, there's inspections, that any inquiries from the tenants are dealt with, right? So we did discuss previously the mandates that are normally involved in the rental space, and those are the two mandates that we see in practice, right? Now, the basis of this question is to try and take a mandate that doesn't really fall within this sphere, sales mandate, where an estate agent would now be the sole agent entitled to sell this property. So we're trying to take a principle outside of the scope, and we're trying to, for lack of better words, you're trying to force it into this rental landscape, right? We're trying to include it in mandates, as an example, that don't typically have these clauses in them. Now, if it was simply a matter of including something in the sales sphere in a procurement mandate or a management mandate, you could probably get away with it. Now, the question is, can it actually be included in the lease agreement? So now the lease agreement typically has nothing to do with the agent. The lease agreement is between the landlord and the tenant. So my off-the-cuff answer is to say that if you try and include a clause that gives you rights and entitlement in an agreement that has actually nothing to do with you, you're already asking for trouble because it's not clean. Sometimes it's argued whether you properly accepted it, because now you as an agent are responsible for signing this agreement. So now there's three parties that sign this agreement, and very often the agents don't actually go off and sign lease agreements, right? So I do feel that there is people are trying to forcefully merge these two concepts together. And I do feel from a neatness perspective, keeping them apart is probably the best option. So if you feel that the landlord should be giving you a sole mandate that during the next year or within a certain period, or if he decides to sell, the mandate comes to you, I would probably suggest get that signed independently, because you want to be able to enforce it, because that actually sounds like a pretty good deal. If you're putting it into a lease agreement and the landlord didn't expect it to be there, there's even arguments in terms of the things like the Consumer Protection Act that go, hold on, wait, I didn't actually realize I was engaging you on these terms. It wasn't made clear. I signed this agreement and maybe I didn't read it, but the reality is I thought it was a lease agreement. And now all of a sudden you're telling me it's not a lease agreement, it's something else. And the courts have found this plenty of times where people understood that they were getting they were getting a loan, and it turns out that there was something in the agreement that made it a sale, and people took transfers of properties by force because the people supposed to repay the loan didn't repay the loan, and they were basically tricked into losing their properties because they defaulted on the loan, and the person had a power of attorney and took transfer of the properties, and the courts have ruled against that. So the only time something like this, where you can merge these two worlds, the sale and rental worlds together, possibly, in my opinion, is if you happen to find this tenant and you're managing the relationship between the tenant and the landlord. And in this lease agreement, you have a clause that says that if these two parties decide that they want to engage each other on a sale, that you were the effective cause of that sale, and by virtue of that, you're entitled to a commission. That, for me, is neat. It's still a merger of these two worlds, but it works because you are basically getting them to acknowledge that there was an introduction. Your primary mandate isn't the sale, but you're saying that if it so happens that they decide to buy and sell, that you gain some benefit from it. That I can live with. Trying to include a sole mandate where the landlord somehow restricts himself from being able to give this to any other agent. It's hidden in a lease agreement. Not neat. I wouldn't suggest it. Probably the landlord would probably have good grounds to push back. And if you did include it possibly in the rental mandate, so let's say in the management mandate, that would maybe make more sense because at least it's a mandate between you and the landlord. But even there, I would rather be very express about what you're trying to achieve. If you're trying to get a sales mandate, say that you're trying to get a sales mandate and justify why you feel that you're supposed to be getting a sales mandate. Because remember, ethically, why would that be allowable? Why would the landlord be forced to give you a sole mandate when he really just came to you for you to find a tenant or manage a property? So there has to be a very upfront conversation as to why a landlord gives up his rights like that, when typically in the industry that isn't a norm. So just be very careful about that sort of thing. I would rather be clean and upfront about it and let the landlord know exactly what your intent is.
Yeah. So there you have it, ladies and gentlemen. Thank you very much, Bruno, for expanding on that question. And then we will obviously be continuing with the mandates and be taking more questions and giving more answers, and maybe we'll create a playlist as well. So that does bring us to the end of today's episode, ladies and gentlemen. Thank you very much for joining us, and we will see you guys again next week.
Cool.
Thanks, guys.
Thanks so much.